Good afternoon, and thank you for attending our online series today, our training series. My name is Berbeth Foster. I'm an attorney, the lead consumer attorney in the Senior Citizen Law Project at Coast to Coast Legal Aid of South Florida. Today, I'll be going over with you foreclosure defense in the wake of COVID-19. And I will be subsequently followed up with Colette Kienle, who will be discussing other consumer-related matters such as garnishments and collections. So we're going to start with, let me share my screen with you all so you can review the presentation today. So again, the title of the training is Foreclosure Defense in the Wake of COVID-19. To begin, in response to the COVID-19 state of emergency that was declared by Governor DeSantis and subsequent guidance from the Florida Supreme Court, the 17th Judicial Circuit issued Administrative Order 2020-27 as well as other subsequent orders suspending non-essential court operations, and that included canceling foreclosure sales and suspending all writs of possessions and default judgments. Now that state of emergency and the administrative orders from the Florida Supreme Court and the governor were extended through June the 2nd. However, beginning June 2nd, effective immediately, the 17th Judicial Circuit has issued administrative orders that allow the clerk of court to resume entering defaults and issuing writs of possession. However, the requirement under the Florida Rules of Civil Procedure for the clerk to issue a writ of possession forthwith remains suspended until reinstated by the Florida Supreme Court. And that order is expected to expire on August the 25th. It's a little confusing, the language of the order. Writs of possession can be issued, but they can't be issued forthwith. Does that mean the sheriff's office are not going to be able to execute on those writs? Since these are really new administrative orders that have come out, we haven't seen them in place yet, so we'll have to wait and see, but we're expecting that it's going to create a lot of confusion and some unfortunate outcomes going forward. In addition, the 17th Circuit just yesterday issued a new administrative order 2020-43 Civ that allows final judgments to be entered and foreclosure sales to be set, as long as plaintiffs complete and file a verified statement of compliance with the CARES Act. And that administrative order is set to expire on July the 1st. We're going to go over shortly, and I'd like to just show you what that verification looks like. So here we are. We have the verified statement of compliance with the CARES Act. And as you can see, it requires the plaintiff to certify that the subject property, whether it's vacant or abandoned, it requires them to certify whether it's a federally backed mortgage issued by and insured by FHA, or whether it's a federally backed mortgage not insured by FHA, or it might not be a federally backed mortgage at all. So that's the really simple certification that the 17th Circuit is allowing plaintiffs to move forward with seeking foreclosure judgments and sales, foreclosure sales, beginning June the 2nd, which is right around the corner. So the state moratorium on foreclosures is ending very shortly. So here, let's talk about which homeowners are protected by the CARES Act. The CARES Act protects federally backed mortgages, and it defines those in the act as first or second mortgages issued, purchased, or backed by the following agencies: Fannie Mae or Freddie Mac, the VA, the FHA, if your client has a home equity conversion mortgage, i.e. a reverse mortgage, as well as mortgages under the Indian Home Loan Guarantee Program and USDA loans. Those are less common loans that are not seen very often. So how do you know if your client's mortgage is federally backed? Well, Fannie Mae and Freddie Mac have both online tools that allow you to look up the client's property address and their name to see if it's owned by Fannie Mae and Freddie Mac. And I've provided those websites for you for your convenience. Keep in mind, you do need the client's last 4 digits of their social security number in order to be able to access that information. So that will be needed for both websites for Fannie and Freddie. If you want to know whether your client has a VA mortgage, FHA, or home equity conversion mortgage, it's probably best that you look at the mortgage document itself. So VA mortgages will have a clause regarding VA approval for assuming the loan. That tells you that it's a VA mortgage. FHA mortgages have an FHA number on it, so that's pretty clear. And a home equity conversion mortgage will be titled just that, home equity conversion mortgage. So those 3 categories of documents require you to look at the mortgage itself. The Indian Home Loan Guarantee Program and the USDA loans require a little bit more in-depth research. You'll probably need to look at the client's HUD-1 and closing documents to find that out. So if you have a client that really has no idea and no paperwork for you to review so that you can determine if they have any one of these federally backed mortgages, then you can always call the servicer and ask, and they'll have that information. And if, for any reason you're unable to obtain that information over the phone with the servicer, then you can do a request for information under RESPA and send it to the servicer's official RFI address in order to obtain that necessary information, because that's really important in moving forward how you're going to defend and assist clients during the pandemic. So the most important CARES Act, or the really first CARES Act protection that we'll go over, is the moratorium. That moratorium forbids servicers of federally backed mortgage loans from initiating, moving for foreclosure judgment or an order of sale, or executing a foreclosure-related eviction or sale for 60 days after May 18, 2020. And that deadline will be July 17, 2020. So no servicer or plaintiff should be moving forward with any sort of originally initiating a foreclosure case or trying to move the case to a judgment or a writ of possession before July 17, 2020, no matter what the status of the case or the client's default. Now, this only applies to occupied properties. So if you'll remember that certification that I just showed you from the 17th Judicial Circuit, they have to certify whether the property is occupied, and it doesn't matter if it's occupied by a tenant or the borrower. As long as the property is occupied, it gets the benefit of the moratorium. Forbearance. So the greatest protection for federally backed mortgages under the CARES Act is the opportunity for borrowers to apply for forbearance. That forbearance can be initially 180 days, and it also provides for a 180-day possible extension if needed. So a client can get originally 6 months, up to 6 months of, protection or forbearance from making mortgage payments. And then if they really need the additional time, say because they lost their job and it's difficult for them to find new work, they can get an additional 6 months. So that's a year of forbearance that they may be entitled to under the CARES Act. And when your client contacts their servicer for the forbearance request, they can't be required to provide any information other than just making the attestation that they are in a financial hardship, whether directly or indirectly, and that was caused by the COVID-19 emergency. That's it. There's no paperwork required. It's just their assertion to their servicer. Once they're granted the forbearance, no fees, penalties, or interest beyond the amount that would be charged if the borrower is making timely payments can be charged or accrue. The servicer cannot do any negative credit reporting during the term of the forbearance. And if you have a client that comes in pre-foreclosure and nothing has yet been filed, if they're able to get a forbearance in place, then the servicer is not allowed to initiate that very first filing of a state law foreclosure proceeding. So what happens once your client is in a forbearance? How do they inevitably resolve their delinquency? Normally a forbearance will end and the borrower or the homeowner will be expected to pay all of those months that they owe to the mortgage company as either as a lump sum or maybe possibly in a repayment plan. But normally forbearance requires a lump sum payment at the end. But under the CARES Act, it's required that servicers reach out to the borrower at least 30 days before their forbearance is scheduled to end. And the borrower has to be evaluated for one of the following options. That would be an FHA partial claim. That means that the loans that are insured by FHA, the servicer can actually file a claim with FHA for them to pay out of that FHA insurance policy to recoup or repay the months that were due from the forbearance agreement on behalf of the borrower. If the borrower does not have an FHA loan, say they have a Fannie Mae or a Freddie Mac, they may be able to apply for a loan modification. There are several different modification options that are available. They may be able to get a repayment plan. Again, they can't require a lump sum payment from the borrower, so they could possibly do a repayment plan, or they can do some sort of extension of the loan term, which is somewhat of a modification in and of itself. So a really great resource that I found is the NCLC Summary of Foreclosure Alternatives for Borrowers with COVID-19 Hardships. And I'd like to show it to you because it's really helpful in breaking down what some of the borrower's options are depending on what kind of mortgage they have. So here we see with Fannie Mae that no lump sum can be required at the end of the forbearance. And for borrowers who can afford their pre-crisis payment, they may get an extend modification, a cap and extend modification, or a payment deferral. For borrowers who cannot afford their pre-crisis payments, then they would possibly be eligible for a flex modification. So the extend modification that's available is mostly just taking the term of the number of payments that were in forbearance and extending the life of the mortgage that up to that amount of months, and it cannot exceed 12 months. A cap and extend modification is similar, but they would capitalize the arrearages first, do some calculations in terms of the interest rates, and then the mortgage can be extended in monthly increments up to 480 months from the loan modification. A flex modification really has its own calculations. It also requires capitalization of arrearages. But as you can see, there's several options that are available through Fannie that would help a borrower catch up on their mortgage payments and not be required to pay everything as a lump sum. We have Freddie Mac as well. Freddie Mac doesn't require a lump sum be paid at the end of the forbearance. It has some of the same similar modification programs that Fannie Mae has. Then you have the FHA insured mortgages. That's the one that allows FHA to possibly do a partial claim as long as the borrower was less than 30 days past due as of March 1st. If a borrower can continue to afford their pre-crisis payments, then that would be the best option. If they can't afford that, then they would have to go through a different loss mitigation loan modification option. So as you can see, there's information for the VA loans as well and USDA. All of these explicitly state that the servicer cannot require a lump sum payment immediately after forbearance, which is really a benefit to our clients if they have a federally backed mortgage. So that information in this worksheet, I will actually make it available at the end of the training for anyone who needs this, as well as the PowerPoint presentation. So moving on. Non-federally backed mortgages. So if you have a client that does not have one of the federally backed mortgages, unfortunately, they're not going to be able to take advantage of the CARES Act benefits. They will have really just the state moratorium relief that's been provided, which unfortunately is ending on June the 2nd. So if you have a client that comes in and they don't have a federally backed mortgage, it's going to be time to really start looking at what other alternatives we can do for them and work with them on, because the state moratorium relief is going to be ending very shortly. Federal regulators have actually issued guidance and relaxed some of the standards that they require for servicers to provide borrowers the opportunity to work out payment arrangements and modifications with borrowers. So that's the extent of what the federal government has done to kind of incentivize mortgage companies that don't have federally backed mortgages to work with borrowers under the circumstances. You should always contact the servicer with the client to see what kind of options may be available. Even if they don't have a federally backed mortgage, they may still have the opportunity to apply for a modification based on who their investor is, or based on the fact that maybe they've never modified the mortgage in the past or anything like that. But it is very important that you caution clients whose mortgages are not federally backed that if they seek and they accept a forbearance, they are going to be most likely required to make a lump sum payment at the end of that forbearance agreement, and they may not be able to do that. And there's no guarantees that they're going to be offered an opportunity for a repayment plan or a modification. So they're really taking a chance by accepting a forbearance. Some of the litigation concerns that you should be thinking about is, of course, the stay on proceedings of the foreclosure sales that's coming to an end, the issuance of default judgments and writs of possession. All of that will start to come back into play June 2nd. So the idea that those benefits were going to be extended a little bit longer is unfortunately not the case, and things are going to start moving along again very quickly. The CARES Act does allow a borrower of a federally backed mortgage to request a forbearance regardless of their delinquency status, and it provides that the forbearance shall, which means the requirement, it shall be granted upon the borrower's request for up to 180 days. So let's say a client comes in who was in foreclosure for 6 months before COVID-19, and they have a federally backed mortgage. They can still contact their servicer, even if they were previously in foreclosure, and advise them that they are experiencing a financial hardship related to COVID-19, and they are entitled to request that forbearance and be granted that forbearance if they have a federally backed mortgage. So that may be beneficial in cases where maybe the case is beyond the pleading stage and may be ready to go to trial, or a motion for summary judgment has been entered, and you don't necessarily see a way to help the client immediately. At the very least, they should be looking into seeking a forbearance to, put the case on pause to try to work some other arrangements out. Litigation concerns. Now, there are strategies that and things that you can do to represent the clients related to the plaintiff's failure to grant a forbearance if the homeowner is protected by the CARES Act and the servicer is not complying with the law. There are equitable defenses such as unclean hands and estoppel. There are also counterclaims that you can bring under the Florida Deceptive and Unfair Trade Practices Act. If you can show that the consumer can claim damages under the act, if they can show that there was a deceptive act or unfair practice, causation, and actual damages. And that should be something that should be, absolutely doable if you have a federal statute set out to protect homeowners and the servicer is not complying with that, and it's going to lead to the loss of the client's home. That is a strong cause of action that can be raised, as well as under RESPA, under some of the same, factual guidelines, failure to comply with loss mitigation under the CARES Act, causation, as well as the actual damages that the client would lose their home, then that's actual damages, of course, that can be raised for the purposes of RESPA. You can also get statutory damages if you can show that there's a pattern and practice of wrongdoing. Some courts suggest that actual damages are required before you can add on the statutory damages as additional. So keep that in mind. Defenses that can be raised that are not COVID-19 related. So if you have possibly a client who doesn't have CARES Act protection, but they come in originally from the beginning of the litigation or early enough possibly for you to file an amended answer, say if they filed a pro se answer just saying, I couldn't afford to pay my mortgage because I lost my job. If you get something at that stage, you should be able to still possibly raise standing, whether the plaintiff in the case is the proper party to bring the action, review the chain of title, the assignments, any allonges to the note any endorsements that may be on the promissory note, and you can raise standing. In addition, failure to satisfy a statutory or contractual condition precedent. Did they, follow the federal guidelines in terms of loss mitigation? Did they send the borrower their contractual paragraph 22 notice of intent to accelerate? Those are defenses that can be raised that are not COVID-19 related, as well as equitable defenses if the plaintiff failed to properly service the loan. Or did they wrongfully force place insurance when they shouldn't have? Have they been miscalculating or charging fees and interest that they're not entitled to? All of those things can be raised and may not be COVID-19 related, but will absolutely give you strong legal defenses to represent your clients. Again, we should also be looking at, can they get a loan modification? It's not always necessary to have a COVID-19 case, but you can also get a loan modification simply if the owner of the mortgage allows that. So what does the owner of the mortgage allow so that the borrower can have some sort of opportunity to become current on their mortgage? And a worst case scenario would be a Chapter 13 bankruptcy. Does the homeowner have sufficient income where they could pay back the arrears and the default amount over a 60-month payment plan through the Chapter 13 bankruptcy court? Some of those things should always be taken into consideration when we're representing clients and trying to find alternatives, ways for them to save their home and remain in the property. Now, just to touch on some other defaults not mortgage related that may be a result of COVID-19, you may have clients that come in with condominium or HOA defaults. In those cases, you would want to first look at whether that client lives in an entitlement city. Some cities are using their SHIP funding that's normally used for rehabilitation and repair of houses, and they're giving funds to their citizens for them to assist them with paying back housing related expenses that they've fallen behind on due to the coronavirus. So every city has its own criteria of what they're willing to pay for and how much they're willing to give. Some may have a sustainability requirement. Maybe the client has to show a budget and an income that's sufficient to show that once the city pays out this money on their behalf, they're going to be able to continue making those payments going forward. Again, every city is different, so that's an opportunity to really look with your client into what opportunities their city might be offering to assist them with defaults that are related to housing, even if it's not mortgage related. Broward County also has limited funding up to $600,000 for cities that are non-entitlement cities, and that they're using those funds that are not a part of their Federal CARES Act funds that they're expecting in the future. The maximum payout to a household is $5,000. Now, applicants are required to prove the status of their income prior to the loss of employment and the reduced income and the status of the current household. So again, that's a sustainability question. The SHIP funding is available on a first-come, first-served basis, and clients have to go directly to Family Success. They can do it via telephone. There's no online application available. And again, all of this money really runs out very quickly. So if you have clients that come up in the early stages of their condo default, this is one of the first things that maybe you can look at. Because unfortunately, when you're talking about condominium and HOA defaults, these statutes are written very condo and HOA friendly, so that you don't really have a lot of defenses here when a client didn't pay. And that really limits what you can do litigation wise. So a lot of this comes down to probably trying to negotiate as best as you can with the condo or with the HOA to see what they can do to help the client get back on track. And that's why we often do budgets in our office with clients. We do budgets to see what their income and what their expenses are so that we can offer some sort of reasonable payment plan to the condominium or the HOA, usually with some sort of good faith down payment. They will sometimes accept a repayment plan. And again, as a worst case scenario, if the condo and the HOA are not willing to work with the homeowner, then they can consider a Chapter 13 bankruptcy to get on an extended payment plan that will get them caught back up at the end of the Chapter 13. And finally, reverse mortgages are another federally insured mortgage. They are not conventional in that the homeowner is not required to make any payments on the mortgage. They only have to pay their property taxes and homeowners insurance. And basically what happens is the equity is being drawn out of the house the older the client gets on a monthly basis. So those reverse mortgages, since they're federally backed, they get protections under the CARES Act in terms of getting an extension of time to call a loan due and payable. And that's subject to Mortgagee Letter 2020-06. What does that mean? That means, well, if your client defaulted because they didn't pay their property taxes or homeowners insurance, or maybe they didn't send in proof that they're occupying the property, all of which are requirements under the reverse mortgage agreement, the servicer normally would call that loan due and payable after getting approval with HUD. Under the CARES Act, if they didn't have the funds to pay the taxes, the insurance, and the mortgage company paid it out on their behalf, then they can request an extension of time where HUD will not call their loan due and payable. They can get an initial 6 months with an additional 6 months if approved by HUD. And in that time period, they can really be working on applying for a repayment plan to the servicer and to HUD for whatever was spent on their own behalf, whether it be for the taxes or the insurance. In addition, if they can't afford the HUD repayment plan, they may be eligible, depending on how old they are, for what's called an at-risk extension, which is an extension of calling the loan due and payable for some senior citizens that are above a certain age and who have or who are suffering from a terminal or serious illness, so that if they are removed from their home, it would have a detrimental impact on their condition. So an at-risk extension is available for older clients who will not be able to afford a repayment plan, but who should be able to stay in the house and not have the loan be called due and payable. And finally, if you have a client that can afford a Chapter 13 bankruptcy, again, going back to doing that budget, looking at their income, looking at their expenses, then a Chapter 13 may wind up being the route to get that homeowner back on track if they can't get any of the other options that are provided and they really want to remain in their home. So that's the extent of foreclosure defense in the wake of COVID-19. I will go ahead and pass the presentation over to Colette Kienle so she can talk about collections and garnishments. Colette?
Thank you, Berbeth. Okay. Hi, my name is Colette Kienle. I am the attorney in the Consumer Law Unit at Legal Aid Service of Broward County. We assist with credit card lawsuits along with garnishment issues. Now, the first part of my presentation will be advocating in credit card lawsuits. Now, due to the COVID crisis, there has been significant job loss and financial destruction within the family unit, and just people have to make the choices even more difficult than before as to keeping a roof over their heads or paying their bills. So we anticipate, although during the court closure, the lawsuits maybe dropped off as far as clients contacting us for assistance, we know that that's just an avalanche waiting to happen. So we do expect that onslaught to come shortly, and so we would like to prepare ourselves accordingly. So if a client walks into my office with a credit card lawsuit, I mean, the first thing we do with any client is you have to know there is a bit of debt counseling involved. You have to discuss priority debts and compare them to the income, explain them to the client as to what is priority, what is not. Believe it or not, some believe that paying their credit card bills overrides paying their association, which as not many clients underestimate association foreclosures, for instance, and the repercussions of not paying a debt, but maybe because they do not know about the priority versus non-priority debt. So we ascertain the client's hardships as well, and we try to increase the client's financial budget monetarily by ascertaining available community sources and financial assistance. As discussed previously, there SHIP funds and other source of Broward County resources to help clients with utility payments during this crisis, possibly association payments. So public benefits as far as our in-house services. So anything to do to increase the family budget to maybe ascertain a solution to the credit card issue. One of the first things as far as the lawsuit is concerned, as with every lawsuit, you want to review service of the lawsuit upon the client and determine if it's proper. Then you go into, in a basic sense, I go into the lawsuit and the creditor claim. Does the debt belong to the client? Are there any disputed charges? Is creditor communications? So believe it or not, there's mistaken identities. There's a Mary Smith, there's a John Smith, there's a lot of common names just with the demographics. And believe it or not, creditors do get it wrong quite often. And one of the other things we do is we determine if the plaintiff is an original creditor or a third-party debt purchaser, which means a third-party debt purchaser, if, for instance, if Mary walks in with a lawsuit with Midland Credit or Portfolio as a plaintiff, it's usually an indication that that debt has been purchased from Synchrony, Home Depot. That is the indication of a third-party debt purchaser. So your client might not recognize, they might recognize Home Depot, but they're not going to recognize Midland. So there's benefits, if you can call it a benefit, to having an original creditor lawsuit or a third-party debt purchaser lawsuit in front of you. And then you take a little glance at the benefits of the bankruptcy in a given situation, whether it be Chapter 13 or Chapter 7, because in addition to the credit card issues, maybe there's also a mortgage foreclosure or delinquency on another path that, depending on where everything is, determines which type of bankruptcy would be applicable. Now, the lawsuit itself, one of the first things I do with a lawsuit, Mary brings me a lawsuit from Midland. I look at possible causes of motions to dismiss. I mean, these are typical reasons to assert a motion to dismiss just on the face, and they're pretty common in all lawsuits, regardless of it being a credit card lawsuit. Venue, legal sufficiency, failure to join indispensable parties, lack of jurisdiction over the subject matter or person. And again, the mistaken identity, the unauthorized use of the stolen identity. If your client is saying right off the bat that this debt does not belong to me, make sure that they file a police report or get that going, or if they have already, to get those documents ready to assert in the case. Another cause of a motion to dismiss is a statute of limitations, and sometimes this is really underestimated as to being a powerful tool, but it does happen where the contract under which the credit card was issued has a certain governing law, and find out that governing law and compare it with the date of the default and the filing date, and lo and behold, maybe you have a cause to assert a motion to dismiss just within those four corners. Or if it's not, if you don't have the contract in front of you, then eventually, you probably would file an answer, which could lead to a defendant's motion for summary judgment if you do see that later. But it's definitely a reason to challenge and look for and litigate. Now, another area for a motion to dismiss is a failure to state a cause of action. Now, I've listed common causes of action that one might see in a credit card lawsuit. And the most common that I see, the common two, probably are account stated, breach of contract. Account stated, typically only one or two statements are attached to the complaint, and that's it. So definitely can litigate a case like that. But as far as a motion to dismiss, I mean, these elements have to be present or they haven't properly pled their cause of action, so definitely could be a cause of a motion to dismiss. So if we do not see any arguments for a motion to dismiss or a motion to dismiss, we asserted one and it's denied. We go further into Mary's lawsuit. We deny the allegations. Again, we assert any statute of limitations that we see, any standing. Now, with third-party debt collection, it is a big problem with standing because they're purchasing debt just as in mortgage foreclosure. The debt is Home Depot has a bad debt and sells it to Midland, and Midland is now the one suing. So there's definitely a paper trail that needs to be looked at and examined, again, through discover techniques, production request, interrogatories, more likely production request, because typically you're only having 1 or 2 statements attached to the claim. You look for a usury, assignment of debt notice to the defendant. Again, another issue, identity theft. Again, I cannot stress more that you keep asserting that defense, even if it gets defeated in a motion to dismiss, because it is definitely a thing that does happen, especially in this day and age. You'd evaluate for any applicable counterclaims, FCRA, FDCPA. A little bit too much to get into this with this presentation, but they are out there. Now, most of the lawsuits that I see with third-party debt collection in my office they end up in small claims court, which is now overseeing claims under $8,000. Now, with a small claims case, usually then there's a statement of claim. Also, it can be called the complaint, but it's titled usually a statement of claim. There's usually a pretrial conference set. It's not necessarily that you file an answer unless you invoke the rules. Small claims rules do apply. So these pretrial conferences, these hearings are set all at one time usually. And sadly, most defendants do not appear, and then they're defaulted. A heavy majority of defendants do not appear, and then a default judgment occurs pretty much right then and there. And even if the defendants do appear, they're usually unrepresented, sadly, where the plaintiff usually always is represented. So definitely an unequal seesaw in that respect. Now, before the pretrial hearing actually takes place outside the door, what happens to the unrepresented defendant or a defendant who proceeds pro se? The plaintiff might approach a defendant before the pretrial hearing and offer to settle. Now, this is very, very, very common. The defendant may have a $1,000, $2,000 debt, and the plaintiff comes up to Mary and says, we'll give you a payment term of $30 a month, and we can be done with this. So Mary may choose to go along with that offer, but I'll explain the cons to that. The pros of that, the benefit to her, it may be that she wants to be done with it and this is something she can afford. The cons are significant and the risk is significant as well, which I'll go into in a little bit. So if the defendant declines the pre-hearing settlement, they go up to the judge, the case is called, dispute the claim to the court, and from there a trial or judgment hearing gets set. Now, if this case is litigated up to that point, sometimes plaintiffs dismiss the case before judgment hearing or trial due to the lack of documents to prove the case, such as standing and the trail of the debt from one entity to the other. If the defendant does not dispute, typically what will happen is the court's going to encourage mediation. In fact, that's usually what I see happening. They want the cases to settle, and the settlement is encouraged. So if the defendant does not dispute the debt to the judge, the court is going to then refer it to mediation, which really may happen right at the hearing. And the settlement will be through a mediator. Usually the mediators are on site. And the typical settlement, whether they settle pre-trial or with the mediator, is that if Mary defaults on that $30 payment, or she defaults at any other provision of that agreement, and in the pre-printed forms which the plaintiff may put in front of them at the pre-trial, they may not see this language, and I probably would guarantee that most defendants do not know that the ramification is that if they default on that, then the plaintiff pretty much has to file one thing and a judgment is entered. So we have to be very leery of those settlement agreements and make sure that the client understands the ramifications if the settlement agreement is breached by her. So if the client tells me that they want to settle, they don't want to bother with it, I pretty much then go very much in detail with what settlement involves, and I do some other evaluations. The if the client is judgment proof, which means they receive public benefits or just something that later on when the plaintiff tries to collect, basically the client has their funds coming in to support themselves are of the public benefits such as SSDI, SSI. This would make the client judgment proof. So why enter a settlement agreement if they're exempt? Now, typically, if they say, okay, I do want to settle, I owe the debt, I try to convince them that's not necessarily true, because they may owe something. If they're morally challenged for not paying, we try to really dissuade that line of thinking. We explain to them in third-party debt suits that typically Midland is buying that Home Depot debt for much less than the $1,000 that Mary might owe. They may buy the debt for pennies on the dollar. So that allows a settlement figure when you enter into negotiations for lower than what the amount claimed in the lawsuit. And we are pretty successful with those types of negotiations. But as with any claim or any negotiation from either party, and maybe either in any lawsuit, should consider the strength of the defenses or the counterclaim and the affordability of the agreement to your client and the hardships that your client is undergoing, and will they be able to pay this amount even if things go south for them financially, they lose their job, so forth, because again, the risk is great if they default on the agreement. So again, they will likely be agreeing to entry of judgment if they default on the settlement agreement. And you also want to discuss bankruptcy again. Either maybe we've had clients where one lawsuit somehow magically triggers 4 unrelated lawsuits on credit card debt, and now you have 5 lawsuits attacking the client, and all of a sudden everything becomes unaffordable. If Mary has 4 payments at $30, and now all of a sudden it's become too hard for her to maintain this. So this leads me now into the next part of my presentation, which is the garnishment section of my presentation. So garnishment, we do get quite a few garnishments, and we expect these garnishments to resume once the judges and the current order expires on June 2nd. So there was a little bit of a moratorium and suspension of garnishments. We did have to assist clients with garnishments that were served right before the court closure and the administrative orders, but we got those resolved. So, but that means though now more are coming because of the unemployment. Again, people cannot afford to pay and they get judgments against them, and here they are facing a garnishment, which is unfortunate, to have your bank account or wages suspended while you are dealing with a pandemic and challenge because of job loss. So the goal of assistance, now there's a lot in this part of the presentation, so I will be going through it really fast, but if you have any questions, obviously you can refer to this or the statutes that I list in here. Now the goal is to preserve, if Mary comes in, now the credit card, she defaulted on the agreement, now the credit card is suing her and garnishing her, they've already sued her, they got a judgment, and now they want to collect. So your goal is to preserve her exemptions, any exemptions that she might have. So I'm going to discuss those. And you also got to really hold the plaintiff's feet to the fire as far as if they're following a procedure in regards to the notices that they need to file. Now, or the bank who gets the order to suspend funds that is due to Mary. So usually, judgment creditor, plaintiff, judgment debtor, defendant used interchangeably. I probably will do so as well. Writ of garnishment is a collection tool. It's governed by Florida Statute 77. Everything you really need to know about the process and the notices are in that statute. Writ of garnishment is submitted to the judge. The judge issues the writ, and it's served on the garnishee, and then the employer serve the writ, and it has to hold up to 25% of its disposable wages. There are exceptions to that I will discuss later. So if Mary's bank account is garnished, then the bank can hold up to double the judgment amount. And you see this is a big problem. It's usually a big surprise that one finds out that their bank account or wages have been garnished, usually when you're in line at Publix, or if your rent check bounces and now you get an eviction notice. So usually the notice comes the hard way. I cannot stress how much service of process, usually it's very important in a lawsuit. It's even more important to examine it in a garnishment, because we've had where the service was an issue going back maybe 10 years. The plaintiff has 20 years to collect on these judgments in Florida. Defendant has a successful challenge, then the case will be unwound. The 120-day period to serve has likely expired. Case might be dismissed and then it'll make that difficult for the plaintiff to refile due to the statute of limitations. So it's definitely a strong tool if you have a good challenge to that service of process. So we have to look at it carefully. Not always easy in the older lawsuits. We get sometimes garnishment 10 years from judgment, and the clerk may not have the documents anymore. So obviously it's challenged a little bit, but if there's any doubt and think that your client is clear and convincing evidence, certainly help them advocate that area of the rule. So the first notice that the client must get is something called the 77041 notice. I call it a 41 notice. It's the notice to the individual defendant of the right against garnishment of wages, money, and other property. This is a notice which defendant Mary gets, which advises her if she has an exemption, she has to file it within 20 days. The plaintiff is they have to serve this notice. They have deadlines, and if they're sensitive deadlines, all these deadlines in garnishment are extremely sensitive. So they must really be paid attention to. There's a time frame the plaintiff serving the 41 notice. Now sometimes they'll go to the wrong address, and then you deal with issues accordingly within 77041 deals with what happens with return mail. Debtor has 20 days, Mary has 20 days. If she's the head of household, she supports her family, she has to assert that exemption 20 days from the certificate of service. Sometimes the language within the notice says receipt. So, the argument can be made of that word receipt. Claim of exemption is filed, and the plaintiff, it triggers other deadlines, which I've listed here on the PowerPoint. Again, you can reference these deadlines in 77041. Failure of the plaintiff to file an objection within those time frames can cause automatic dismissal of their writ. So we get a few like that. That's obviously a good thing for our client. Now the second notice, once the garnishee, there's a second notice. It's called 77055. This is a notice of the right to dissolve the writ, and they have to serve. The plaintiff has to serve this notice. It's a 55 notice that the defendant Mary has to move to dissolve the writ within 20 days from the certificate of service date. Now with that, they also provide a copy of the garnishee answer. Again, there's a time deadline, sensitive deadline. And with the garnishee answer, for instance, if Mary has a bank account with John, and now the Bank of America, it's a Bank of America account, and they answer the garnishee, the Bank of America answers the lawsuit with saying Mary and John own this account, they have to provide this notice to John as well. And failure to provide it, again, is a basis for dissolving the writ. And then there's a 20-day deadline to file the motion to dissolve, and this can address missed deadlines, any complex arguments concerning an exemption or any other argument to dissolve, and it actually can serve. You don't want it to come to this, but you can maybe, if your client missed the claim of exemption deadline, they certainly can try to use it in this motion to dissolve. It is, after all, an argument to dissolve the writ, and you can file both the claim of exemption and the verified motion to dissolve. Sometimes you don't have enough room to explain on the claim of exemption form, as you will see, so you need a little more space for your argument. Now, this is a worksheet. Maybe it's not readily visible, but I suggest you start a worksheet as to to keep track of these deadlines and to see when these deadlines hit and if the plaintiff has complied and what has been done. And when we're talking judgment, we're talking judgment amount plus usually daily interest is accruing. So a debt from 2007 for $2,000 maybe is up to about $4,000 or $5,000 now, maybe more. Sometimes the interest is more than the debt, unfortunately. But this worksheet is very helpful. These deadlines are all over the place and they have to be tracked carefully to preserve your client's rights and to hold plaintiff to the fire. This is a typical looking claim of exemption form. It's a one-page form. It's templated. So you'll see there's room to handwrite the case number, plaintiff, defendant, garnishee. Usually this is the ones that the clients file or defendants file. You can see maybe not so well head of household. Head of household is probably the most common exemption. I'm going to move along to the actual explanation. There's 12, but as you'll see, there's 12 listed exemptions. Most of them supported by the Florida Constitution and also to Florida Statute 222. Some other miscellaneous statutes as well, but federal law as well supports some of those exemptions. Too much to go into in detail with this presentation, but head of household is the most common, and there's an under $750 a week and over $750 a week of disposable earnings. The difference is that over $700, if your client makes over $750, Mary makes over $750 a week in disposable earnings. The difference is that basically she can agree to have her wages garnished, but it has to be a conspicuous writing. And Florida Statute 222.11 describes that in detail as to how that writing must look. It can't be hidden, it has to be in a certain font, separately from everything else, but together as well. Now, the dependent can be a minor or an adult, and then the case law supports liberal interpretation of what a dependent is. If Mary if Mary supports her mother who lives in the house and can show that she provides over half the support, then that is a dependent. Mary's mother then would be a dependent. Disposable earnings, we're talking about gross earnings minus mandatory deductions such as Social Security, etc. Exemptions 2 through 11, they're miscellaneous, federal, allowed by federal or state statute. You'll see that on the form. Now, exemption 12, other exemptions. There's only a short amount of space in that claim exemption form to explain that. You're better served to explain it more in a motion to dissolve. Here's public benefit exemption. Usually there's an automatic, the bank usually, if it's a bank levy, usually they'll detect it and automatically assert the protection. It has to be direct deposit. It cannot be transferred to another account. That automatic protection is lost, but still can be exempted, but you don't want them, it's obviously a big benefit with that protection in place. Look back period. Now, item 12, there's a list of other possible exemptions that I've included here. Low-income debtor, you can't garnish somebody below 30 times the federal minimum wage per week. It's a calculation. It's pursuant to the Consumer Credit Protection Act. You cannot, and you also cannot exceed 25% of disposable income per week. So if Mary has 10 garnishments or 1 garnishment, she cannot be brought below the low-income debtor status, and she cannot be garnished more than 25% of her disposable income. 1,000 property exemption under Constitution, 4,000 under the Florida. If Mary doesn't claim homestead, she rents, she gets 4,000 in personal property exemption. A $1,000 motor vehicle exemption. If Mary doesn't have a car, she can add it to her 4,000, but can't add the 4,000 into the 1,000. She can't add more than the 1,000 into her motor vehicle exemption. There's other things that need to be filed, inventory affidavit to assert 222 protections, garage sale value for these items, not replacement value, not going to Rooms to Go and buying a couch for $500. She can sell her couch for $25 at a garage sale. That's what it is. Deadline. Now, there's sometimes non-judgment debtor. John is not a debtor. He hasn't agreed. He hasn't agreed to take responsibility for this debt. So he has things to file and the motion to dissolve the writ and a non-debtor affidavit as well. Tendency by the entirety, we do encourage our clients to open accounts this way. It's held as one, not divisible, and just basically loses its status if as long as, you know, if divorce happens or something like this. But this is a good tool in a bank account. The claim exemption hearing, client has to bring documents to support their hearing, to support their exemption. Head of household, such as tax returns, pay stubs, anything. They have to be prepared. Not going to just take their word for it. You can try to submit the documents to the plaintiff, maybe get a voluntarily dismissed. The court tries to hear it as soon as possible, but it still may be a few weeks, which, you know, the landlord doesn't care. So the sooner that the money gets back, the better. If they're just dissolved, take the court order, get the court order to the employer. It gets sent to them anyway, but maybe by mail. So it might take another couple weeks to release the funds, which the client can't afford. Could be another garnishment. They have to be on the lookout. Maybe think about resolving or bankruptcy. And even if defendants late with deadlines, Mary, we still encourage her to file a claim of exemption. The judge may order to hold all the funds going from the hearing backwards, but may allow her to have her the garnishment dissolved going forward. And if the court denies a claim of exemption, or if the defendant doesn't respond at all, judge is likely to grant motion for final judgment and garnishment and order the garnishee to submit the garnished funds to plaintiff. Right now, until the garnishee gets an order, they're holding the funds. So right now, until the court issues that order on the motion for final judgment, the garnishee is not releasing it to the plaintiff, again, unless they get a court order. So I've included some language here. I don't know if it can be read. Verified motion to dissolve writ, the sample head of household argument, again, liberally construed. You can see that in the Kienle case. And another language as to motion to dissolve, maybe the personal property exemption with the checking account, and, you know, which is included the funds in that 4,000 or 1,000. The inventory of personal property, again, example, garage sale value. And also the affidavit of exemption, which, again, these are just samples of wording. And this concludes, thank you very much. This concludes the online training, and we hope this helps you to understand garnishment and credit card issues and be able to help clients going forward. Thank you.